Hello, and welcome to BLR's HR Compliance News Update. I'm Steve Bruce, and we have significant new compliance requirements to relate to you. On August 27, 2013, the U.S. Department of Labor's Office of Federal Contract Compliance Programs, or OFCCP, announced a final rule that makes significant changes to the regulations implementing Section 503 of the Rehabilitation Act of 1973. Section 503 prohibits employment discrimination against individuals with disabilities. BLR Senior Legal Editor and Affirmative Action Expert Susan Schoenfeld joins us to explain how the new regulations will impact government contractors. Susan?
Thanks, Steve. Before we begin, I'd like to talk a little bit about exactly when these rules will take effect. According to OFCCP, the new rules will take effect 180 days after they are published in the Federal Register. Publication is supposed to occur sometime in mid-September, which would put the 180-day mark in March 2014. So, as of the effective date, contractors must comply with all of the elements of the final rule, with the exception of Subpart C, which applies to the new Affirmative Action Program requirements. OFCCP will provide contractors with additional time to come into compliance with the Affirmative Action Program, or AAP, requirements. What this means is, contractors with a written AAP in place on the final rule's effective date may maintain that AAP until the end of the plan year and delay their compliance with Subpart C, the AAP requirements of the final rule, until the start of the new AAP cycle. The 180-day effective date and plan phase-in period gives us all a little more time to become familiar with the new rules and to ensure that we are ready once the effective date and plan years begin to turn over. So let's talk a little bit about the new regulations implementing Section 503. The new rules create many new requirements, including the most important of probably of which is the 7% utilization goal. Now, under the 7% rule, covered contractors and subcontractors will be required to establish a new 7% utilization goal for individuals with disabilities. OFCCP arrived at this 7-point figure primarily by using information taken from the disability data collected as part of the American Community Survey, which is a census type of collection effort by the U.S. government. Under the new rule, covered contractors and subcontractors with more than 100 employees must use the national 7% utilization goal, and in most instances apply it to the same job groups that is created for compliance with Executive Order 11246. If you are a small contractor using the EEO1 job categories as your job groups in your Executive Order AAP, OFCCP says you can apply the 7% utilization goal to your EEO1 job categories. Now, if you are a much smaller contractor with a total workforce of 100 or fewer employees, you may apply the 7% goal to your workforce as a whole and need not break out the utilization analysis into job groups. So how else covered contractors and subcontractors get information on disability? Well, the new rules spell out the self-identification process. Under the new rules, applicants must be given the opportunity to self-identify at both the pre-offer and the post-offer phases of the application process by using a form or forms that are yet to be made by OFCCP for this purpose. Now, for existing employees, the rules also require that a contractor invite what they call incumbent employees to self-identify every 5 years during employment by using prescribed language, again, created by OFCCP. And the rules also require that the contractor must remind employees that they may voluntarily update their disability status at any time during employment, and this reminder must fall at least once during the 5 years between invitations to self-identify. Now, under the new rule, contractors must also collect specific data relating to applicants and hires on an annual basis, and they must maintain that data for a period of 3 years. The required data is, first, the number of applicants who self-identified as individuals with disabilities or who are otherwise known to be individuals with disabilities. Second, the total number of job openings and the total number of jobs filled. The total number of applicants for all jobs. The number of applicants with disabilities hired. And finally, the total number of applicants hired. So once contractors collect all of this data, what does OSCCP require that they do with it? Well, under the new rule, a utilization analysis is required. Covered contractors and subcontractors must conduct an annual utilization analysis, an assessment of problem areas, and establish specific action-oriented programs to address any identified problems. So if the contractor's analysis shows that the percentage of individuals with disabilities is less than the 7% utilization goal, the contractor must take steps to determine whether there are impediments to equal employment. This includes assessing things like existing personnel policies and processes, the effectiveness of outreach and recruitment efforts, the results of affirmative action program audits, and any other areas that might affect the success of an affirmative action program. So after conducting this assessment, the contractor must develop and execute action-oriented programs to correct any identified problem areas. So OFCCP says that the failure to meet the 7% utilization goal won't be a violation of the regulations, and it will not lead to a fine or penalty or sanction. However, failure to set a goal or conduct the analysis and assessment of problem areas may result in adverse action by OFCCP. So that is an area to be aware of. In addition to the changes I've just discussed, I've wanted to point out a few more important changes that are also included in the final rule. Just very quickly, the definition section has been changed so that the definition of disability under Section 503 has been brought into line with the definition of disability under the ADA after the ADA Amendments Act. As you most likely know, the ADA Amendments Act did expand the definition of what a covered disability might be, and now Section 503 adopts that more expansive definition. In addition, the new rules addressed EO clauses, requiring contractors to state in solicitations and advertisements that they are equal employment opportunity employers of individuals with disabilities specifically. Now, the final rule permits contractors to incorporate the EO clause into subcontracts by reference by citing a very specific text stated in the rules themselves. That text is relatively short, but it must be in bold text and it must be verbatim from the rules. In addition, the new rules address the issue of electronic posting. When the contractor has employees who don't work at the contractor's physical location, OFCCP will now allow a contractor to satisfy the posting requirement via posting the EEO notice in electronic format. However, if the contractor decides to do so, they must be able to show that these employees who receive the notice have computers that can access the electronic posting, or that the employee has actual knowledge that the electronically posted notice is accessible to its employees. Finally, I want to talk a little bit about compliance evaluations. The process of compliance evaluations is impacted by the final rule. First and foremost, the final rule cements OFCC's position that it may obtain information that's pertinent to a compliance evaluation for periods after the date of the scheduling letter. To those of you who are familiar, this is the Frito-Lay rule, and the new rule basically makes that more formal. Now, the rule states that OFCCP can extend that temporal scope of evaluation and examine information after the date of the scheduling letter only so long as OFCCP deems it necessary to carry out an investigation of what it has found to be potential 503 violations. In addition, contractors will be required under the new rule to inform OFCCP of the formats in which they maintain records and other information, for example, Word and PDF and Excel. And then OFCCP is allowed to select the format that it desires from the contractor's available formats. Finally, OFCCP can also request that contractors provide documents either on-site or off-site during compliance checks, and OFCCP may conduct focused reviews both on and off-site. The final rule does not mandate that contractors list job employment opportunities with the American Job Centers, nor does it require that the contractor enter into linkage agreements as it did in the proposed rule. Instead, now the final rule requires that contractors undertake what OFCCP calls appropriate outreach and positive recruitment activities, and the rule provides a number of suggested resources that contractors may use to carry out those recruitment obligations. So that's a very quick view of the new Section 503 rule and what it will bring for covered federal government contractors and subcontractors. Back to you, Steve.
Thank you, Susan. For the latest information and updates regarding changes to the Section 503 regs, visit our OFCCP Regs for Federal Contractors Resource Center, which can be found at hr.blr.com/resource-centers. Also, see our related video on the new changes to the regulations implementing the Vietnam-era Veterans Readjustment Assistance Act, or VEVRA, which prohibits employment discrimination against specified categories of veterans by federal government contractors and subcontractors. For BLR, I'm Steve Bruce.